benefit of his son. The court finds that he is unavailable because he committed suicide, and he makes statements in here that, in these statements about making these statements so that if something happened to him, they would be.
Welcome back, everybody. We're going to break out of our review of testimony in the Eric Campbell guilt phase trial to switch gears and bring you back to a case that wrapped up with a big turn of events for a defendant, John Valerio. This is a case we covered earlier this week and last week here on the LawNewz Network. Valerio, accused of murdering a prostitute 31 years ago. He was originally convicted on murder charges and sent to death row. Many, many years later, decades later, the Ninth Circuit Court of Appeals at the federal level overturned the conviction due to bad jury instructions. Turned out the state of Nevada was supposed to change its jury instructions because the U.S. Supreme Court said certain phrases in those instructions were unconstitutional, but the state didn't do it and kept going on with the same instructions for 15 years. Well, the federal courts have come in and ripped up all the convictions in those subsequent 15 years. So the bottom line is this defendant, John Valerio, had another death penalty guilt phase trial. The question was not whether he was guilty, but whether he was supposed to be punished a certain way. So his punishment was up for question, I should say. The punishment this time around was life in prison, not the death penalty. So his defense attorneys ultimately saved him from a death sentence. He's now going to spend the rest of his life behind bars. But they did not go so far as to convince the jury whether or not John Valerio should eventually get out on parole. The jury decided he should not get out on parole. The prosecutor in the case, one of several prosecutors that handled the retrial of the death penalty phase of that trial, is going to be joining us here on the LawNewz Network in about 20 minutes. So in the meantime, let's listen to his rebuttal argument. This was a very good rebuttal. It made a lot of great points. Let's listen to that. We'll be live with the attorney in about 20 minutes.
At least everything that happens with the jury in the room, it's really about essentially one thing, and that's a search for the truth. And normally in guilt phase type proceedings, it's a very simple concept. What did the person do? What do the facts establish? And what's the law? And you make an application of those two together and decide, hey, did the state meet their burden or the state didn't meet their burden? And then ultimately you could decide, is he guilty or not guilty? The unique exception of a penalty phase is that it's not just a truth-finding function. And there is one, and we'll talk about what that truth is. But there's also something else. We allow the jury to decide sort of what matters. Does something matter or not? Should we consider a particular piece of evidence, even if we find that evidence to be true? And that's the concept in this particular case, right? Mitigators in general, you get to decide, does it really mitigate his punishment or not? But the question sort of that's been presented in this case is one where you have to ask yourself, the 31 years, does it matter or not? And whichever one you choose to go with, does it mitigate his crime or not mitigate his crime, you still have to answer that first essential question. You know, they say that justice delayed is justice denied. Why do they say that? Because you get punished for what you did, not who you've become. And so in this case, there's really no way to give a full measured amount of justice because it has been 31 years. But why do we say it's been justice delayed is justice denied? We would care if Mother Teresa committed a crime. That would mitigate her sentence. But we as a society expect that once you've committed your crime, you don't get to go back and make amends for your punishment. Your actions afterwards are what you're supposed to be doing. And despite the fact it took him 15 years to stop committing the infractions, he doesn't get 15 years of freebies. That doesn't increase the sentence, not reduce it. And the other thing when we talk about should we or should we not consider it, what you need to start with is a concept of motive. Motive is complex. People don't do things on a routine basis for a single reason. So in their world, in this case, John Valerio stopped committing offenses at age 36, 37, whenever it was, because he suddenly became a good person. Really? Well, you heard Sherman Hatcher say, well, yeah, almost all our prisoners age out. Do we really think the Department of Corrections is working so well that our prisons are rehabilitation all of our prisoners? Because all of our prisoners are aging out. They stop making violations. Okay. Well, what about, I just became a good person? What about the fact that, you know, hey, look, you know someday a guy like me is going to be standing up here talking about it. So, is that a reason for you to stop? And the answer from Dr. Reutemann is this. He couldn't control himself. That's his answer. He should have continued to commit violations. But why the heck isn't everybody else who's aged out in the prison system continuing to commit violations? What about Mr. Valerio is unique? You heard Sherman Hatcher say it. The guys that are housed in his specialized unit, like Mr. Valerio, they behave the same way they do. Infractions, 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 until they finally figure out the hole's a bad thing. That deprivation is a bad thing. So the question you have to ask yourself is, even if it matters, are you willing to accept the word of John Valerio that he's changed? Because what does Dr. Reutemann really say? Well, I talked to John Valerio, and because he hasn't had a violation, it must be true. I mean, if you were going to see Dr. Reutemann for a medical diagnosis, you'd sue him for malpractice for not looking into any of the evidence that underlies this case. Because he starts with a basic premise in this case, which is the actions of John Valerio are always impulsive. He can't help himself but to commit this crime. He can't help himself for all the other choices he's made because he can't control the urges in himself. And we know that if that were true, he wouldn't continue to commit violations. Really? What about any of this evidence is impulsive? Now, there's another thing you should learn, and I should have said this before I started, about the truth, which is, don't ever rely on what lawyers say. I just sat here and listened to both Mr. Pesci and Mr. Pitaro. I was in the same room you were. And Mr. Pitaro spent a whole bunch of time saying, Mr. Pesci just said to you 20 minutes before that John Valerio was definitely going to be paroled. Did you hear that come out of Mr. Pesci's mouth? No. What Mr. Pesci said is he'd be 11 years late for his parole hearing. He didn't say he was going to get paroled. The other thing Mr. Pitaro said, oh, Sherman Hatcher said there's very few people who come back to prison after serving 30 years. Ooh, that's not what Sherman Hatcher said. Sherman Hatcher said about 50-50 come back. Then after he realized, he just said that half the people that get released on parole after 30 years in prison come back to prison. Then he started qualifying. Well, yeah, a lot of them are for violations of their parole agreements and when they go back into custody, and I'm not aware of a whole lot of people who've committed violent crimes. That gets muted by Mr. Pitaro to very few people ever go back to prison after getting parole. So when you talk about the truth-finding function, no matter what I say, no matter what they say, the truth-finding function of a jury is not based upon what you hear, it's what you read. It's what you see from the witness stand. And you are going to, at some point, have to make this determination. You're going to have to figure out the truth of just this one question. Who is the true John Valerio? Is he John Newton? Or is he the person who did what he did to Karen Blackwell? Do you feel comfortable knowing the answer to that question? Do you feel comfortable that John Valerio has suddenly found in life redemption? Because he said it? Everybody knows the story of Amazing Grace. Everybody knows that a prisoner says, hey, I've changed, I've learned from my mistakes. And apparently, if you're Dr. Reutemann, that means there's nothing wrong with you and you'll never commit a crime again. But let's go actually to what the evidence is. There was a mention of the parole board. And, you know, they have all these great records and they know what they're doing. the suggestion to you, and I think I heard him say, Mr. Pitaro said something about life with the possibility is trite. It seems trite. It seems ridiculous. If you're on your third felony conviction, you get the minimum possible sentence, right? I mean, don't we reserve the minimum possible sentence for those people in this world who made a mistake in their life? Not the guy who's on his third strike. There's a reason there's 3 strikes and you're out. He committed 3 violent offenses before this murder. And you say, I deserve the minimum possible sentence. He suggested that Mr. Pesci and I reject the idea that someone can change. God, I hope so. I'm a prosecutor. I hope people can change. I send people to prison in the hopes that there's going to be rehabilitation. But I'm also a realist. For all the John Newtons in the world, there are 10,000 John Valerios, maybe 1 million John Valerios. Somebody who there is 0 evidence of his actual change. I mean, look, you heard that there's some woman named Katie Stevens who apparently finds a prisoner online and has communications with Mr. Valerio. And that person is important in his life. Except for when you hear about Dr. Reitman, who talked to him on 3 occasions. I never heard about a Katie. There was some Elaine for the last 25 years. Take the evidence as a whole to decide who John Valerio is. In the 80s, even before that, the 70s, I know Mr. Pitaro has cited John Newton. I'm going to suggest to you, there's Billy Joel. Billy Joel wrote a song. It's called The Stranger. And he's talking about something that we all understand and none of us really think about. There's the person we present to the real world, and then there's that person that's in the deep thoughts of our mind. The true person that you are, the true you. And Mr. Joel asks the question in one of his songs, did you ever let your lover see the stranger in yourself? The question being, do you have anybody in your life that knows the true you? And that's the question as we sit here today. Is John Valerio the person that he's portraying in his statement to you, the unsworn statement to you, yesterday or Friday or whatever day it was? Or is he the person that Karen Blackwell met? And in order to know that, you have to know the evidence. So think about who John Valerio is on September 19th of 1986. First, you know he's on bail from an attack upon a woman named Angela Howard. And what does Angela tell you? She says, yeah, he puts the gun in my face, but once I realize he's in the car, that it's going to be a robbery, he tells me he just wants my money, I tell him, fine, I'm going to go get my money. And she bends over to get the money. It's at that point he calls her, he says, you bitch, and he hits her over the head, and the gun discharges, which clearly scares him off, and he jumps out of the car and runs. What is it that he really was planning on doing with Angela Howard? What did he learn? Because he learned a little bit from his first crime against Mr. Henderson, right? He pushed him down, stole his wallet in a casino. Oh, that's a bad idea. So what is it this time? This time he's hiding behind at a restaurant, waiting for his prey to come to him, and he learns a lesson, which is, hey, it is really hard to kidnap somebody. It is really hard for a stranger kidnap, even if you hide out behind a restaurant and a woman by herself is getting into her car. Things can go wrong. So what do you know now? 30 days later, he wants to do what he wants to do. And you ask yourself, does this make sense? Well, yeah, he learned again. And to be honest with you, he just got really unlucky because he probably shouldn't have ever been caught. What do you know, and we didn't talk about this, but it's all in there in the transcripts, because there's a truth-finding function. You should go back there and read those transcripts. You'll know that Karen Blackwell is an out-of-work nursing assistant who couldn't find a job, but she had a little girl that she had to make money to support. And while the choice wasn't the best choice in her life, she chose to be a prostitute. And you learned from that she placed ads, and from those ads she had numbers and names, and from that you could figure out who she was, Roxanne and the phone number, and the cops were able to verify that information. But the one thing you also know is she did something highly unusual, and the only thing that ever allowed the police to figure out it was John Valerio. She wrote down the names of her Johns and then starred the ones she went to and put their addresses. And had she not talked to her boyfriend, Barry Kozlov, that night and say she was in the area of Tropic Paradise and she was going back to that same area, had that little fact and that book not exist, John Valerio never gets caught for this crime. It is a sophisticated crime, and what you know about it is something else. It is highly premeditated. Why? One, you know about his behavior beforehand, where first he did it in the casino, then he had tried to attack a woman out in the street, and that didn't go well. Now he brought her to him in a confined area, and what do you know did he have? He had to have a blunt instrument, and I'm going to suggest to you, you know he has a gun, because it's found in the washer. He has the ability to use that weapon just for a robbery. He has that ability to use that weapon if he just wanted to kill her. But that's not just what he wants. He's got an orange zip tie. Why does he have an orange zip tie? What does he intend to do? He needs it for what? It's not a ligature. He needs it for control. He has to control this woman for what he's going to do for her. And they made a lot of fun of Detective Vaccaro looking at photographs. Trust me, crime scene reconstruction is not rocket science. You know, gravity is gravity. Things go up, they come down. When blood is flying through the air, it goes in directions. But you can look at that crime scene, you could stand there and you can imagine some things that are absolutely beyond a doubt, which is as she's disrobing, he hits her over the head with that blunt object. And as she goes down on her knees, dazed and everything else, he gets control of her by putting the orange zip tie around her. And I agree with John Valerio. When you're on your knees, you begin to pray. And I bet you that's what Karen Blackwell did. And as he has her now in control, how do you know that this wasn't a swift attack? As Mr. Erickson, I think, said to you, Dr. Coates says this was like a blitzkrieg attack. Dr. Coates never said that. They asked him about, in times, have you seen where there's an act of rage? And he says yes, but they never asked him, in this case, do you have an opinion as to whether or not? Because how could he possibly have that opinion? This isn't rocket science. You don't need to be a medical doctor to know certain things. Do you remember Dr. Hollander said, I don't think that's the knife, because if that's the knife, there'd be hilt marks. And then she explained what hilt marks are. It's when the knife hits into the skin, it makes a mark for where the hilt of the knife is. What else did she say? Well, when you're hit in the head, I imagine it had to have come first, because I can't imagine someone would sit still for all those wounds. Well, what is she saying? This woman has 45 stab wounds, and her hands are cut twice. She's got a cut in the arm 3 times. 45 times a knife's coming at her. She's defending during this? No, she's not. She's being controlled. Look at the knife wounds themselves. There wasn't a great amount of force used, according to the defense. Absolutely. That's exactly the point. If this was a blitzkrieg attack, you'd see things hitting the bone. You'd see the hilt marks from the knife going in. No, you don't see any of that. What happens if you were to get a knife stuck in your neck? What would your initial reaction to be? It'd be to pull away. It'd be to rip it away. You'd have cuts and slashes. You'd have hilt marks from the knife going in if this was a... No, this is slow. It's painful. And it takes a long time. And why is it so slow? Why is he over her, controlling her, slowly sticking a knife in and out of her neck? Why is she unable to stop it from happening? And you heard from Dr. Coates and Dr. Hollander. This isn't a quick death for Karen Blackwell. Her lungs are filling up with blood as she can't breathe. Her liver is bleeding into her stomach. She gets a knife wound that causes her to lose control of her body function from her neck down. Mr. Pesci talked about the thoughts of Karen Blackwell between the time of stab number 1 and stab 45, but looking at this crime scene, that isn't like 45 stab wounds like this. Mr. Valerio took the time to slide a knife into another human being 45 times. What does that suggest to you about what he was doing? Impulse? That's an impulsive behavior? No, that's not impulse. That's just downright evil. And the one thing Dr. Royton could agree with me is that the underlying character of a human being does not change. Evil does not change. And to suggest to you that you should get an opportunity for parole because you can recite, I don't think about the enjoyment of pain on another human being. The only person in this world, well, maybe 2 people, I would suggest to you, Angela Howell got introduced to the true John Valerio, but she didn't stick around long enough to really see.
Welcome back to the LawNewz Network. We're joined now by Marc DiGiacoma, who is the Chief Deputy District Attorney in the Homicide Unit at Clark County, Nevada. He was one of the prosecutors who handled the John Valerio case. Marc, it's good to see you here on the LawNewz Network.
You too.
Well, we just watched the rebuttal in the closing argument there, and wanted to start out with a threshold inquiry. This was a case where you had to retry the penalty phase of a trial 31 years after the original crime. So did that result in any frustrations from your standpoint in trying to get this all lined up some 31 years later?
Oh, there's huge problems with doing something like this. I mean, ultimately, most of our witnesses were either dead or unavailable. So it was hard to tell the jury what the story of the crime was. I mean, ultimately, that's what they're sentencing for, is for the crime itself. And we were literally down to a detective who was the best homicide detective I've ever worked with, but at the time he wouldn't have been in homicide for 7 years at the time the crime occurred. So it wasn't like he was even around back then. So we had some real difficult problems kind of presenting all the evidence in a way that made sense and that a jury would be able to absorb it and not see it as just an intellectual exercise as opposed to real life. Someone died and there was a real victim here.
Yeah, and something that is not necessarily fresh in mind as well. It's hard for people not only to get into the head of what happened, but one thing that I remember saying is, like, look at how much the world has changed. These neighborhoods have changed. You live in a community with a drastic growth. There's tons of new construction. This is a crime that happened back when people were still using rotary dial telephones. People were still carrying address books, and that was one of the critical pieces of evidence in the original case. So just look at how much has changed over the years.
Oh yeah, absolutely. I mean, these days we have cell phones, we get information from them. I mean, one of our facts in our case is that the homicide detective who winds up shooting at Mr. Valerio is there alone because his sergeant got called away on a pager and had to go find a payphone to make a phone call. And so he winds up being left alone. It really makes you think about how different the world was back then and sort of the situations. I haven't seen a real life newspaper utilized for personal ads in a very long time, and we had this old yellow piece of paper from 1986, which was the personal ads of our victim.
Yeah, exactly. Now, you talked about witnesses being dead or unavailable, and I think it's critical from an evidence standpoint to sort of split the two, because a witness who has passed on is by definition unavailable, but there are other reasons why witnesses may be unavailable. And I think in my research, I found out that a couple of the witnesses whose testimony was read back into the record were just very aged at this point. Is it just that they were not in a state to remember what they had testified to 29 years ago?
Somewhat. I mean, luckily we were in a penalty phase, and so the rule of unavailability and hearsay didn't apply. So when I use the term unavailable, I don't mean it in the technical legal sense. But for example, Dave Hatch, who was the one who attempted to take him into custody and wound up shooting at Mr. Valerio, he's in an advanced state now. He's not only just old, but he's also got severe medical problems, and just couldn't make it to a courtroom.
Yeah, I mean, making it all the much more difficult. You did key in on what my next question was going to be, and it's sort of interesting that the hearsay rules don't apply in these hearings. So that probably did help you out despite many of these witnesses not being available, because you could have someone else discuss it tangentially.
It did. I mean, 31 years later, unfortunately, these people are sort of constrained to a police report. And as prosecutors and defense attorneys, as attorneys all know, there's only so much information that gets put in a report anywhere. The actual small details, the minutiae of the case that really give it life are rarely found in police reports, but people usually, a couple months after the crime, remember these facts. This we were putting on. It really was difficult to give a true feel for what happened and sort of the circumstances of the killing and everything else, just solely from police reports. But certainly not having the hearsay rules apply was helpful to us.
One thing that we did not get a sense of from where we sit in Midtown Manhattan is whether or not the victim's family was still available, still in communication with your office, or whether or not they were somehow involved in this proceeding. Were they, and is there a reason why we didn't hear them speak?
Her daughter at the time was 10. Now she's in her 40s. Over the years, I've talked to her on a number of occasions, and she kind of went back and forth. And ultimately, on this occasion, she said to us, I've found peace at where I'm at, and I think it would be more harmful to me to relive this experience than just not coming whatsoever. Sort of as a side note, she had asked us when the case first came back for a picture. It was State's Exhibit number 20. It had been lost over time. Nobody could seem to find this picture, but it was the last picture she had with her mother, and her mother's sitting with Santa Claus and her. And she said, the only thing I want out of this is that picture back. And we spent a lot of effort trying to find this thing. We could never find it. And then the morning of the last day of trial, a box shows up in our appellate division, and in that box is a bunch of photographs, one of which has a marker as Exhibit number 20. So we were able to get that photograph back to her. But that's really all she wanted at this point, that she had moved on. And shockingly, she is a woman who has a family, she has children, she has a job, a career. Despite what happened to her mother, she was actually able to make a success of herself in life.
Well, that's good to hear. It's sometimes rare to hear when families who are distressed by just the most horrible circumstances like this can carry on. So she sounds like a very strong person. A question about what got us to this point. Why did Nevada keep this so-called depravity of mind instruction active so many years after the U.S. Supreme Court said that it's not supposed to be used? Because my understanding is that that's why the Ninth Circuit ripped up the original death penalty verdict in the first place.
Well, what happened is that the instruction for depravity of mind was given in a bunch of cases. And then the U.S. Supreme Court comes back and says, hey, that's too broad, it's unconstitutional. The Nevada courts then limit the instruction. But for those cases that were tried before the limiting instruction was given by the Nevada Supreme Court, they had to then be reassessed. And the Nevada courts looked at this and said, oh my God, look what happened to this woman. Clearly this is torture. Clearly this meets the limiting instruction. Then it was the Ninth Circuit who said it was inappropriate for the Nevada Supreme Court to do the analysis. And so that's why they sent it back, was because the Nevada Supreme Court shouldn't have been the one to limit the aggravator and then apply the facts. They said that had to be done by a jury.
Well, let's talk a little bit about the jury, because that's another critical element that we don't see here. We really don't want to see it, okay, because the jury's the jury, okay? We don't want to put them on TV. They don't want to be on TV. There's reasons to not have them on TV. But someone sitting in the courtroom, and certainly someone sitting in your chair in the courtroom as prosecutor, is trying to look at the jury and get a sense of how the jury's reacting to pieces of evidence, pieces of testimony, to see, are they engaged? Are they losing interest? Are they not following things? Did you get a sense of how the jury was following this case? And if so, could you share a little bit of what you were taking from them?
Oh, it was clear from the beginning that this jury was taking their responsibility quite seriously. And it turns out we wound up with what it was a very good jury at the end of the day. They asked questions, and unfortunately, they kept asking the one question that probably would have made a difference at the end of the day that we couldn't answer for them, which is, why are we here 31 years later? Why didn't this happen in 1988? The questions kept coming over and over again from them. Eventually, we worked out a stipulation where we sort of suggested why we were here without telling them what the prior verdict was. And as it turns out, talking to the jury afterwards, that was a major thing for them. That if they had had that answer, if they had known that he was on death row for the last 31 years, they probably would have put him back.
That's an interesting perspective, because I heard the stipulation and I was wondering what was behind it. I sort of assumed that maybe it was just in case the parties were afraid the jury was asking that question, but we didn't hear them actually asking that question. Some of that has to do with what's audible and what's not when we pick up the feed, but I didn't hear them actually asking that question when they had the chance. So that observation is an interesting one. The stipulation, I thought, handled it, but you've got to, I mean, just to get inside the heads of the members of the jury, look, they've got the defendant himself getting up there and giving this allocution. Okay, jurors got to be wondering, why has this guy been in prison for this long, and then suddenly we're back here 31 years after the crime? So I assumed the question was being asked. I didn't know that it was being asked quite as often as you've said.
Yeah, what happens when a jury asks questions? They actually have to write it on a piece of paper, and then we all go to sidebar. The judge reads them. If the judge isn't going to ask the question, he doesn't make mention of them, comes back out. So in this situation, after each of the witnesses that related to, anything to his time in prison, Sherman Hatcher, Norman Reutman, those people, they kept 4 or 5 questions from different jurors asking essentially the same question, which is, what happened in 1988? Why has he been in a special housing unit for 31 years? Why hasn't he ever moved to general population? I mean, every question related to ultimately that issue, which is, why are we here 31 years later?
And just to hear it from you for our audience, again, why is it that we don't want jurors to know that the guy has already been on death row?
Well, if we tell them what the verdict was before, that is highly prejudicial to the defendant. If they know that another jury has already given them a death verdict and they're just reaffirming that question, then they're not doing sort of an independent analysis. They're just deciding, did the first jury make the right decision?
Exactly, and then that basically would negate the whole point for having a second death penalty hearing that the appeals court required to be done in this case. So we wanted to avoid that, but I can imagine that was frustrating for everybody. I know that everybody's got their clients to represent. You're representing the people. The defense attorney is representing the client. But just knowing that the jury is getting frustrated must have then frustrated everyone else.
To a certain extent it did. I mean, look, the defense tried to limit as much as possible any suggestion of what that prior verdict was. We were able to get in, that the order came down for the new trial in 2002, to suggest that he had other reasons to change his behavior. But certainly it was really frustrating, and certainly after we talked to the jury and found out that, what the vote was and what ultimately the resolution was, knowing, as they said, had they known he was on death row, that the vote might have gotten to 12-0 for death.
What was the vote? Are you able to share it with us?
My understanding is that they took an initial vote in which they said, take your conscience out of it, just decide what does this guy deserve, and it was 10-2 for death.
Wow.
Yeah.
And then it wound up flipping.
And after a while, they... Excuse me? I didn't catch that.
Oh, I said, and then my reaction was just wow, and then they wound up going with life without the chance for parole. So that's a big shift.
It is. I mean, the irony of it all is that the Ninth Circuit sent it back because they said the depravity of mind aggravator, the instruction was not harmless error. Well, this jury found depravity of mind as well. So apparently it was harmless error, but he got a benefit out of it. He got 12 more jurors 30 years later with a different standard of society looking at his case again, and he was able to get lucky, and it's hard to get 12 jurors to agree to that verdict, certainly harder than it was 30 years ago.
I was afraid that this might be another one of the cases, because we cover so many of these tight issues here at LawNewz, and we wind up with hung juries. I was wondering if this was going to be such a case, because there are strong arguments on both sides, and I thought the case was well litigated on both sides. But the fact that they were able to switch from 10 to 2 down to a unanimous 12, going against the majority of the original vote, says that this jury, as you pointed out, was taking its job very, very seriously. I get the sense from what you're telling me that you did get a chance to talk with them, and what I'm hearing is that this probably was an amicable conversation at the tail end of the proceeding, or I should say after the proceeding was over, to try to understand what they were going through, and then maybe say, okay, this is what we couldn't tell you before.
Right, and apparently the judge had gone back and told them all, and by the time we saw them come out, as I told them in closing, we were going to respect whatever verdict they give, because that's the system we rely upon, and neither myself or Mr. Pesci thought that they did anything other than their duty, that they did their jobs, and ultimately the conclusion they reached is not one that either Mr. Pesci and I are offended by in the least bit. As long as, if they had come back with life with the possibility of parole, I'm sure Mr. Pesci and I would have been very disappointed in the result. But apparently that was never a chance. That was never in the hunt for them, that it was really a question of whether or not they were going to give them the ultimate penalty or not.
Now, I wanted to ask as well, who was on the jury? Was it an older jury, a younger jury? Was it a mix? Was it an even split, men and women? Can you give us a sense of what the makeup was?
Yeah, it was generally an even split between men and women. The average juror was probably close to 40 years of age, meaning they were a teenager at the time, at most, at the time this crime occurred. We had a couple of jurors who weren't even born when this crime occurred. So we had some younger members of our community on this jury. I don't think we had anybody who was more than about 50 years of age. So certainly nobody that was a full-fledged adult in 1986. Everybody else was either a teenager or a young adult or hadn't been born yet.
Interesting to sort of get a bit of a window into who was on the jury. What did you make of the defendant's allocution, where he gets up there and speaks for about 6 minutes and 50 seconds and basically tells his story?
Yeah, I think a good allocution for a defendant is very effective. Particularly in capital cases, if a defendant sounds sincere. I got to tell you, when he said it's every day that I think about what happened to Karen Blackwell, that caught me, and it did some of the jurors too, and we wound up talking to them. That's not really a statement of remorse. Remorse is what I did to this human being, and he didn't really say that, and that sort of gave a window into really John Valerio and who he is. I mean, the whole idea that he is a changed human being was, something that I thought there was zero evidentiary support for it, and I think the jury agreed by rejecting every single mitigator he offered.
That's interesting, because I didn't pick up on that myself, and frankly, neither did anybody here. It's so rare that we cover this stage of a trial that perhaps I just don't have the experience in hearing allocutions that you have, Mark, but I don't know if I necessarily took him as remorseful. I did think he was relatively sincere. Remorse, I don't know if I necessarily said he was remorseful when I was in the moment and when I was analyzing it as it was going down.
Yeah, I mean, but to me, allocution's all about remorse. Anybody can say, I've changed and I'm not going to do it again. But let's be honest, John Valerio has never been in the position again to commit the crime he committed. His crime is suggestive of somebody who has a sexual motivation and a hatred of women, and whether or not he really even knows himself, whether or not if put back in that situation he'd do it again, I'm not sure even he knows.
You bring up a couple points that you made in the closing argument, and I commented on the air, and I don't know if you went back and listened to it, but I said I thought it was one of the best rebuttals I had ever seen. My only criticism was that in a couple places I think you may have gone a little bit too far, but again, who am I to sit here and armchair quarterback it? But
I've heard that before, though.
Yeah, well, I mean, that's my job. So,
right.
you always have the fear of overselling a case in front of a jury, and there were one or two times where I'm just like, I don't know, maybe that went a little bit too far, but the point you just made was the point you made in the closing, and that's that this crime was horrific, and it points out, as you just said, someone who has either sexual predilections or, as you just said, in your own words, a hatred of women in some point. And I think without your closing, this thing would have not gone anywhere near the harsh penalty that it did go towards, because the closing, I thought, made a lot more sense than the actual evidence presented.
Yeah, I mean, that was the difficulty of the case. If we had this case in 1986 and we had the live witnesses, we had the ability to ask the medical examiner questions that just weren't asked of her by the prosecutors. I mean, law has changed a lot in the last 30 years. I've read a lot of transcripts from before and what we did now, and I felt like I had to put it together for them. So, because I didn't think the jury was going to go back there and do what a guilt-phase jury does, which is look at all the evidence and try and decide what happened each moment of that day. And I actually didn't go as far as I was going to go. I sort of stopped with this was slow, it was painful, and it was depraved, and for lack of a better term. But I was going to keep going on why he picked Karen Blackwell, why he picked that day, and all of that. But I felt like I got the point across for purposes of penalty.
Yeah, sometimes an old news director of mine sometimes used to tell us sometimes less is more. I think that you made the point, you made it very strongly, so I understand why you decided to stop yourself. I don't think you needed any more than you did. Sometimes just saying it once, if it's powerful enough, is indeed enough. Let me ask you about this. The ultimate weird crux, the weird twist of this case is that this guy gets convicted. He goes to death row. He's on death row for, I think, 29 years for a crime that happened 31 years ago. The appeals court overturns it. He gets a second bite at the apple, and all of his mitigation evidence is all of basically his life story of the last 15 years he's been behind bars. I can't for the life of me think of another case, at least off the top of my mind, where a defendant on death row just suddenly gets a second bite at the apple and then says, oh, I'm a reformed man, but all of my good deeds and my good works are the result of the last 15 years of my life, which is really only half of my term of incarceration when I thought I was going to be put to death. I mean, talk about just a strange twist.
Yeah, it's quite strange. I've wound up, and Pesci has done one of these as well, and sort of it's really odd to have mitigation that involves post-crime behavior, because normally we arrest the guy, he's sitting in the Clark County Detention Center, you assume he's not going to do something that's going to give us more ammunition, and then we go to trial and we're all talking about what happened to him at birth, or his mother was an alcoholic, and that's sort of the mitigation in the case. They floated out here that there was a divorce in the family, but half the world comes from a divorced family. So they really only had, well, yeah, I was bad for the first 15 years, but the second 15 years, look at how good I am. And that means I'm now pro-social. And it was odd. It was also hard to sort of dispute because there isn't any real evidence to rely upon. But it was also sort of hard for him to present. There isn't really people you can go talk to. What am I going to say? I talked to the other death row inmates, and he said he was a good guy. They had a real hard time from their standpoint as well.
Yeah, and then you've got the minister who, again, I took her as being a sincere person. I think she sincerely believed what she testified to. But honestly, I really started to take exception to it when she was waffling on the beliefs of her denomination. And again, I take her as a sincere person who sincerely tries to reach out to people who most of the rest of the society just wants to lock them up and throw away the key. But, she's like, well, I don't really know if my denomination is against the death penalty. Well, I pop onto Google when she says it, and lo and behold, they've got a whole part of their website talking about taking ministry steps to try to end the death penalty. So, look.
We had the same website up on Mr. Pesci's computer, and I didn't feel the need to get there and ask her questions. And Giancarlo turned to me and goes, "Oh, I'm going to go ask her a few questions, but I won't go too far." And I think he cut it off well. Look, there's no question in my mind that she was a death penalty abolitionist who got on prisonpenpals.com, found a death defendant who was facing a new penalty hearing, and decided she was going to come be a witness for him. Is she sincere in her beliefs that he doesn't deserve it? Yes, but that's really what was happening here.
Yeah, I mean, is that the legal issue to be decided? And I don't know if it necessarily is. Well, just a couple more questions. I always like to let our audience get to know attorneys who they've just watched litigate an important matter. So how long have you been practicing law?
A little over 18 years now.
What do you like about it the most?
Honestly, a rebuttal argument. That is by far the best time of being a lawyer. There's nobody who gets to get up there afterwards and say, no, that's not quite true. Nobody gets to dispute what you have to say, and you have the opportunity to take all the little threads of evidence that the jury's heard and hasn't really thought about and put back together. It gives you the ability to tell a story that is exciting and fun. I mean, I could tell you that it's also about justice and all the other stuff, but truly from a personal perspective, I love that last few minutes with the jury.
That's interesting because, frankly, that's where I thought you were at your best in the trial. So my observation is matching up with your motivation. So why prosecution? Why not defense? Why not, white-collar crime? Why not corporate, legal issues, business associations?
Well, I'll be honest with you, I never thought I'd be a prosecutor. I sort of accidentally fell into this job by deciding my second year of law school to come be an intern for the then DA Stu Bell, and he offered me a job and I took it. Over the years, obviously I've had opportunities to go do other things, but there's nothing quite like feeling the righteousness of what we do, feeling like you're helping people. There's no billing, there's no business association with it, and I don't have to deal with defendants, which is the worst part of the criminal justice system, is dealing with the people who are perpetrating crimes on other people. So from my perspective, this is the greatest job in the world.
And finally, there is a jersey hanging on the wall above your left shoulder. What is it?
I'm guessing you're seeing the Joe Montana jersey that's hanging up there.
Okay.
I've got a couple of them in here. If it's the red one, it's Joe Montana.
Well, it's number 16 and it's red and white. So why